109-472, State of Kansas v. Timms.
May it please the court, Your Honor, Kevin Shepard appears on behalf of Daniel Timms. I'd like to reserve 2 minutes for rebuttal.
2 minutes is granted.
Thank you. Your Honor, this appeal concerns what happened and how we treat Daniel Timms' election to proceed without counsel. The first time he was charged with a DUI offense in Topeka Municipal Court, what he did was he proceeded without an attorney and entered into a diversion agreement, and there was no waiver of counsel. And
there's no waiver of counsel?
There was,
the diversion agreement had a waiver of counsel, didn't it?
It does say that, but I mean, not an effective waiver of counsel. I guess that should be really a more appropriate way to say it. There is something that he did sign, and it's contained, there's some language. Whether that can be an effective waiver was decided really in Hughes. Is if you just write out the written waiver in State v. Hughes, that would not suffice. There actually has to be some sort of conversation with the judge, making sure that there was a waiver. And here, there wasn't such that conversation. The state can't prove that even happened. I'm not saying it didn't happen. I'm just saying there was no proof that it happened. So, in essence, it didn't happen.
Mr. Shepard?
Yes.
In Hughes, was it just, I mean, how extensive was it? Because here it said you have a right to counsel. Counsel will be afforded if you can't afford it, or appointed if you can't afford it. I mean, it gave advice of the right in addition to saying, I waive. I mean, it wasn't just a signature on a document or something. There was on a court file. I mean, we've seen cases where there was just a signature on almost nothing.
Sure, and they just say, well, you waive your right to counsel. I mean, I know there was more language than just that, but there was just a signature behind it. There wasn't like more of a separate. It was contained within the whole document, and there wasn't really a separate conversation done to make sure that that Mr. Timms understood exactly what he was waiving at that point in time, which is why Hughes mandated that had to be done in particular.
But
yes.
Wasn't Hughes a plea? So we're talking about a pretty significant factual distinction here, whether he was waiving counsel to enter into a pre-trial agreement versus whether he's pleading guilty to the crime.
Herein lies the rub.
Yeah.
Whether or not Hughes can apply to a diversion agreement, and why it should for a DUI diversion agreement, which is distinguishable from any other diversion. And you look at the DUI statute itself, you only can enter a diversion one time per lifetime. There is no other crime that explicitly states that. It's once, you got one shot on a DUI. It's a stackable defense, and it can eventually lead to a felony when you've had your third. Now we now have a look back period, but at the time, Mr. Timms, the look back period was lifetime. But in essence, that there is a stackable offense. It is a required jail offense that you will serve actually a minimum mandatory sentence if you break the diversion and you are convicted because you enter the stipulation of facts. The other thing that's distinguishable, and it's not the only one that is distinguishable, but in KSA 22-2909, there is 2 crimes for one is DUI, the other is domestic battery, where it gives some special provisions that have to be contained within the diversion, and all that language that the statute put in there, it rises to the level where counsel is necessary, and it gets right into what Hughes was talking about, what the person is waiving, what the person is giving up. I understand where the state is coming from on the practicalities of it, that it does create an extra step where diversion can be something that you get the one shot, you move on, and hopefully it never happens again. Because the idea for the diversion is that this is a first-time offense, and they will give you some grace.
How would it work in your mind here? A diversion is an agreement, doesn't involve the court, is an agreement between an accused and a representative of the state, or in this case, the city, correct? It doesn't, the diversion agreement itself is you will abide by these certain conditions within this certain time period, and if you do, the case will be dismissed. How is it that the court would even get involved in that transaction or that agreement, it's really a contract?
True. And if the case was never filed in court, that would probably make a lot of sense. I know that's kind of quizzical, but the charge has to be filed. However, if before they filed the charge, they reached out to the defendant, said, "Hey, we're going to file this charge. You want to enter a diversion?" Then it wouldn't be a court case, but it is a court case, and the courts do monitor the diversion. I have to appear several times in front of the judge and let them know we're going to resolve this by diversion. They do monitor, and the courts do put when my client posts a bond upon his DUI arrests, he doesn't even get the bond back right away. They hold it until the diversion's over. So the court has some involvement here. And it's not to say that it doesn't. I mean, the charge is right there. It is a filed charge. If they had an agreement saying, if you break this diversion, we're going to file the charge, we might have a different scenario.
How does the violation of a diversion result in incarceration?
Well, there's a stipulation of facts. And I can understand that. I think it's less.
You understand what I'm asking?
Right, I know. It's not as strong of an argument to say that, well, every stipulation results in a conviction if it's a violation. You just, when the motion to revoke is filed, you stipulate it, and.
But it's not the revocation of the diversion that has the potential of incarceration. And here, it's the subsequent proceeding that results from the revocation.
Right, but if you have a revocation, just like a revocation of probation,
and then you have a right to counsel.
Exactly. At that, you have the right to counsel, but before if they waived it, and I'm not saying they didn't have an opportunity to get counsel, but if you waive it, we just got to make sure before you enter the diversion, you understand what that waiver is. And the courts, because it's filed in as a filed charge, the courts are involved. All they have to do, it's a pretty easy procedure. When we show up to court to say we're going to enter the diversion, we produce it, our client is there. And the judge just makes sure that it's waived, that the client is there. I'm not sorry, the client, but the defendant is there because the counsel wouldn't be there. And he has to show up. Judge says, I've got this diversion agreement. You waived your right to counsel. Now it's in. Now it's filed.
So really, the upon revocation, we don't have an automatic conviction. We don't have automatic guilty plea. But what we have is a confession. And so, basically, defendant has agreed to go to trial on stipulated facts, which is in essence his confession that these facts can be presented. So we're really not talking about conviction. We're talking about waiver of Miranda or waiver of right against self-incrimination, because the court could still take those stipulation facts and say, well, no, that didn't prove the crime or whatever. So you have another step. What we're talking about is we have one more step that you don't have in Hughes.
I agree with that. I didn't put that argument into my petition for review or even my brief below, but that is an interesting point, is that the stipulation itself also needs to be with counsel because of what the impact it has. Go ahead.
No, we've got a statutory right to counsel. You'd agree with that?
Absolutely.
And so tell us why that is elevated to a Sixth Amendment right to counsel.
Well, in the same sense that you just stated, is that, you are putting down, for one, you are putting down a statement that you agree with these facts, or that you will not challenge these facts, and that the state could produce these facts, and these facts would be sufficient to find you guilty. That's a statement, and therefore that should be done with an effective waiver. So that's one. And number two is, again, what that does is gives the courts the opportunity. I'm sorry.
Counsel, I'm sorry if I may interrupt for just a moment. Before you go on, I want to capture that point. You get an automatic Sixth Amendment right to counsel because you may waive some rights. I mean, that's not true in an interrogation situation. You have to invoke your right to counsel, right?
Well, to invoke your right to counsel, I mean, if you're in custody and you are being questioned by police, that's the Fifth Amendment? I mean, you have a Fifth Amendment right to remain silent, and
To remain silent.
right.
But if you want a lawyer there,
But
I think the question was about the Sixth Amendment right to counsel. Where, if anywhere, does it arise in this situation? And you said, well, he's giving up some rights by entering into the stipulation, and therefore he has a right to counsel. But I don't think that follows necessarily, because a defendant or a potential defendant who's being interrogated, those people, despite our best efforts as lawyers, perhaps waive rights all the time. They waive the right to silence, they waive the right to have counsel present for the interrogation, and there's no lawyer there.
I hate to agree
Critical
with you on
stage.
that. I hate to agree with you on that one. But I see your point.
Yeah, we're not in a critical stage.
Yeah, I mean,
at that point.
because you're not. I mean, we're not in custody at that point, so therefore, I see what you're saying.
Okay.
And
I just wanted to stop you before you went on because I didn't want to miss that point. You can go
But
on.
in effect, though, because that statement is made, it then what naturally flows from that stipulation once it's entered is now the revocation yields a conviction, and the conviction then yields actual statutorily mandated jail time. With that, the defendant has a right to make sure he puts in a knowing waiver, one that's not even just spelled out in writing, but one that is done orally in accordance with what the court held in Hughes, which is based on United States Supreme Court law, or United States Supreme Court precedent. So what I'm arguing, and I think the Court of Appeals made an error on, was that with Paletto, they made this. They indicated that this diversion was not a conviction because there was no actual jail time, but there is actual jail time in DUI conviction for a DUI conviction. And what somebody does when they enter a diversion is they run that risk of during that year on a filed charge in the courts is they run the risk of it being, if they don't follow the diversion agreement, just like they don't follow a probation agreement, of serving that time. So therefore, it is unique, it is special, and for a DUI case, a DUI diversion is like a conviction. Also, in the fact that it will not be dismissed, and that's the other distinction that's really huge here, is that the diversion will count as a conviction in a future prosecution. Diversions count, whereas in no other crime does it, not even in domestic battery.
Did Mr. Tim serve any time as a result of his diversion?
No.
I mean,
No.
I think the record is not real clear, but it appears as if he completed his diversion.
Right. It's not clear, but
successfully.
I'll be totally candid. He didn't serve any time. He completed his diversion. I mean, I don't know if that had. I mean, it doesn't seem like that was a relevant fact in whether or not somebody places or puts an effective waiver in, but he did not serve any time.
Counsel, your position is that the Sixth Amendment requires a right to counsel at a diversion, during a diversion. Does that include the right to have the state provide counsel for indigent defendants?
Yeah, it would.
And so my question then is, aren't you potentially going to win the battle and lose the war if we agree with you? Doesn't that completely undermine the function and rationale of diversion agreements, i.e., why would the state enter into a diversion agreement if they have to provide counsel?
Because the statute gives an opportunity to have them.
But it's purely discretionary. The state's not required to do it. I just think your argument will have the practical effect, if it's adopted, of dramatically reducing the number of diversions that get entered into for DUIs.
When you say win the war, win the battle, lose the war, I'm not so sure I agree with that part. And just in my practice, I'm not saying that every defense attorney that handles DUI cases feels the same way, but I'm very reluctant to advise people that come to my office, especially even when they say, just make sure I get a diversion. I'm like, well, first let me see if you have a defense, because of it's so similar, the diversion is so similar to a conviction. Other than the 2 days in jail, it has all those same effects. So I don't advise my clients to just jump into a diversion, even if they feel like, hey, I made a mistake. I want to look through everything. So I think personally, I don't know if that's really losing a war. If the courts say, you know what, let's just take the diversion label off these DUIs. We count them as convictions anyway. Let's not call them diversions anymore.
Well, for other purposes, it's especially significant to not have it be a conviction. Not just for how it's treated as a prior, but there's all kinds of implications of having a conviction and having a case dismissed.
Not as much anymore. I mean, that's the other thing. This diversion agreement, it does end up going on the driving record, not as so much of as a suspension, but by itself. But the suspension actually shows up if it's initiated administratively, and more often than not it does. But also the diversion agreement does end up on the driving record. It can have some implications, and it's really easy to find these days. So it's not, and I've even seen some legislation this year that for professional licenses, that the diversion will even have some consequences to a professional license, whereas it didn't have that kind of effect anymore. A DUI diversion has the same effect in just even for employment purposes, as it has a whole lot more meaning than it used to have.
Any further questions? Thank you, counsel.
Thank you.
May it please the court. Again, I'm Tim Leisman, Assistant County Attorney for Jackson County, representing the state on this case. And of course, we feel the big issue in this case is the claim that we can equate a diversion to a conviction or suspended sentence of something or something like that. And we simply disagree with that. There's not an underlying sentence imposed on a diversion. There's not time to serve. There's no probation. The whole concept of stipulated facts. I think we get to a point where for the defense argument to be successful, we have to equate stipulated facts with sort of a sham or a guaranteed conviction. And sure, a lot of people that enter into diversions, the facts may not be in their favor. So if they're stipulating to them, maybe things wouldn't go well down the road. But it doesn't necessarily equate to a conviction. It basically means the police reports and the things of that nature would go in front of the court. And at the point that the diversion's entered into, we just don't feel there's a Sixth Amendment right to counsel at that point.
But there is a statutory right.
It appears that there's a statutory right, and it's our position that in this case, that statutory right, which is outlined in 22-2909, was in this diversion agreement. And
As long as you're on that point real quick, if you remember, one of my questions to your opposing counsel had to do with what was in the agreement. And the agreement recited that the counsel would be appointed, didn't it?
I thought it recited that it could. I might have to refer back
that it could
to
be if he desired counsel, or if you just desire counsel cannot and are indigent, it can be appointed for you. So it actually it recites like a Sixth Amendment kind of right, but it's not. It's statutory. I just thought that was peculiar.
I think that that may have been in reaction to some of the previous case law.
Okay, yeah, I mean, it's an old diversion agreement, obviously. Do you know whether the current one, the one that's used currently, says that, has that?
For
in it?
for Topeka, I don't know. I don't know if the Topeka one does. I believe that ours has pretty similar language. And again, it wouldn't surprise me if that was a reaction to the statute, which was a reaction to some of the 1980s cases that came out.
I just thought that was an interesting thing to include if you think it's just a statutory right.
But nonetheless, we still believe that that's all it is, and that was agreed to. It was brought up earlier that, you know, essentially what this could be considered is a waiver of to the stipulated facts, maybe encroaching on a Fifth Amendment concept. Well, I mean, after somebody waives Miranda, lots of people are pretty darn close to a conviction after they waive Miranda in an interrogation. So I don't think we can make that jump. And then, of course, our caution is, you know, where would it end? We're in a system where, and this is true of perhaps all systems, there's sometimes a one-way ratchet of forms and requirements. And so I think another question is, you know, would another layer of forms and requirements, I think in this case what the defense is asking is a judicial certification, putting the person in front of the judge and saying, hey, these are your rights. Does that really benefit us? Does that really get at the heart of, if we do think there's a constitutional trigger, does that even get at the heart of those protections? Or again, is it just more forms, you know, more layers to no end? And that's why because who diversions help is, I would call, the first and only time offender. The person who really is just going to offend once and we're never going to see him again because they're going to successfully complete it and move on. That person pays their money. They don't want to show up to court 3 times. They don't want to be pay more in costs for counsel and things like that. And if we impose some of these other requirements, there will be costs added to the system. And it's that first and only offender who pays the cost, who completes all the terms and requirements. Whereas maybe the repeat offender isn't so successful in those regards. So I don't want to see something that results in just a benefit to that repeat offender, when really the diversion process is a good thing for that once and only time offender. And I think you know, some of the other aspects of this case, we follow this case train going way back to Priest, and it moves on to Nichols and Shelton and some of the cases cited before us. And even though we have a lot of law and writing in those cases, it still seems that ultimately there's an eye test. That, hey, if somebody really is subjected to a suspended sentence, they enter a plea, they get convicted, then yeah, right to counsel, Sixth Amendment applies there. And I'm not trying to belittle all the case law, and it's gone back and forth, so clearly reasonable minds have disagreed to some extent. But it seems that there is a bit of an eye test, and I would submit to the court that the diversion doesn't pass that eye test. Here's somebody that the word diversion, you divert, you're going around the traditional path just a little bit. And you sign a piece of paper, benefits conferred upon you. We generally follow the contract rules. And of course, this contract is modified by KSA 22-2909. But if you complete it, forgive me, I forgot the statute. There's another statute that allows you to say, I don't have a conviction. And that's a benefit. That's the diverting. We're moving around. And I don't want to see that go away or eroded, because if we do equate the two, then what's the point?
How does it, getting back to what has been called a waiver, who is it that communicates this to Mr. Timms? Isn't it the city prosecutor that did this? I mean, I assume it was a meeting between the prosecutor and Mr. Timms, and it's the prosecutor that explains the right to a speedy arraignment. I would say most citizens don't understand what the legal term arraignment means and what the implications are. What does speedy mean? How much time does that mean? Who explains that?
Well, I think you're right that
Your adversary?
if we are to identify a entity that produces this form and goes over it with the defendant, it would be the city prosecutor in this case. And you could, make that analogy. In any case, it's going to be that prosecution body because they ultimately produce the
Well,
the
no,
forms.
not if you have a lawyer.
Oh.
Your advocate's going to. If you're appearing in front of a trial court and there's a plea, the judge will, as in Hughes, the judge will make an inquiry and then certify in some fashion that those rights have been explained. In this situation, it's your adversary that's explaining your rights. And does that equate to a knowing? It might be voluntary, but is it knowing?
Well, certainly we allow police to garner rights waivers in the case of Miranda. As far as concept of, do people understand, can a layman define what an arraignment is? I'd offer that after somebody goes in front of a judge and comes out, a layman might not pass that test of what an arraignment is. But can they get a general sense, a knowing understanding of what their rights are, that they have the opportunity to go in front of a court, to go through the process, to get counsel? Do I think they understand that, even from an adversary presenting them with a piece of paper? Yes. And especially, with DUI offenses, we see a lot of productive people are first-time DUI defendants. They can be sophisticated and understand exactly the benefits they're getting and what they're giving up. I think I've covered all the points that I wanted to make. I'll stand for questions if there are any.
Any questions of council? Thank you.
Thank you.
You reserve 2 minutes for rebuttal.
The rebuttal that I wish to make on this is about the presumptions, what the defendant knows and what he doesn't know by the prosecution when he applies for diversion. The reality is the diversion process is not. It doesn't take a very in-depth look to who this person is, other than the fact that he puts an application in. They look at the criminal history, make sure it's his first. They look at to see if he has any other criminal background. However, I think there's a presumption that there isn't, that he's sophisticated or not. That wouldn't be something that is done by the prosecution in reality, and I don't think that there's anything that would show us that was done. I don't think, and also, I'll go ahead, Judge.
It has to be instigated by an application, doesn't it?
It does, and
It
then
used
there.
to be, and my recollection, of course, I suppose that's different office to office, that there had to be some level of competence to complete that application form. Maybe it's more simple in today's world, but in the old days, some assessment of capability could be gleaned from looking at the application.
Again, it's another presumption that the that defendant filled that out and put all this together. And again, it wouldn't take a whole lot of effort to have, since it is a court case, it's a filed court case, for the defendant to appear to make sure that he understood everything he was waiving. And that's from the broader question for all diversions, in that sense of what rights you're giving up when you sign all that. Do you actually understand what those mean? And a right to counsel is a big right, especially the fact that nobody was there to on your side to explain to you if you had any questions. If the defendant has any questions, he asks the advocate for the other side, to the prosecutor.
How's that different with what we allow on a Miranda waiver? they're simply set forth, typically, read along with me as I read, and we have them sign off, and I don't see that that's a lesser right being waived than on the diversion form that explains the right.
Well, statutorily and constitutionally, the due process of what happens when a charge is filed in court, that there was a finding of probable cause. There was a charge that a judge made a finding that there was probable cause to file, and the person had to appear before they can even put the application in. Therefore, it is different than before a judge even got involved in a custodial confession or custodial interrogation.
I was talking more in terms of our confidence in the waiver being knowing. If we could find that a Miranda waiver can be knowing because they read these words on a piece of paper and sign it, why would we say that the diversion waiver of counsel, where it has it on the piece of paper and they've read it and sign it, that we would presume that that's not necessarily knowing in that context, but we accept the signature as being at least prima facie evidence of knowing waiver on Miranda.
Well, there is a procedure that the courts will look at to challenge whether this was a knowing waiver, and so there is a judicial procedure for that. It's not like that the court just examines whether or not he said yes, I'll waive my right to Miranda. It goes into a whole lot deeper analysis than that.
I understand all that, but what you're asking us to do is say that this former diversion cannot be counted because it's invalid, because we must presume that he didn't give a knowing waiver. Isn't that what you're really having to get
Right,
us
but
to
not
do?
on a case by case basis. I'm asking this court to find that there is not a knowing waiver unless it's presented and it's enunciated by the court, and the person actually waives it before the court after he's heard what rights he's giving up. So there is a difference. I mean, that's the similarities to what would happen if somebody was going to rise to the confession, is that he gets in a diversion agreement, he does get the opportunity to have that done and sealed, and now we don't have to go to a further proceeding to find out whether it was a knowing waiver through a evidentiary hearing, as we would on a confession.
Any more questions? Thank you, counsel.
Thank you.
We thank you both for your arguments this morning. Court will take this matter under advisement.